Carrie Severino, welcome to Constituting America's Constitutional Chats.
It's great to be here. Thank you so much for having me.
Well, we're so happy to have you. And we'd like to ask if you'll start with just a few opening comments on the selection of judges, both the appointment process, how some are elected, and just how judges are chosen in our country.
Yeah, and like so many things in our federal process, there's actually a lot of ways that judges are chosen in our country. And so I guess I'll just kind of go through a bunch of the different ones. And one of the geniuses of the system, as our framers noted, is that it does allow for what they've called laboratories of democracy. So while federal judges are chosen one way, you'll see that the states are chosen in a lot of different ways. And different states have kind of switched over the course of time to different ones, because it really allows us to see some of the pros and cons of the different systems of selection. So I'll start quickly with the federal system, since that's the one that most people are most familiar with, especially every few years when we get a major Supreme Court nomination, everyone starts paying a lot of attention to judicial selection, right? And we've seen several of those in the last few years. Justice Breyer, who's now in his 80s, also, there's a lot of talk of when maybe he will retire. So we may see another one of those coming up even as soon as this year. So it's good to have a primer and a reminder of how this process works. At the federal level, the judges are designed to be politically selected, but then once they're on the court, they're specifically exempted from political pressures to free them from the needs to curry favor with one group or another while they're on the bench. The idea is we want our judges, we want a process that's going to select the highest quality possible judges while having judges that aren't going to feel like they have to make friends with either one political group or the other to stay in office, or maybe one just type of plaintiff or another, because they're going to have to look for a job after this. So here's how our framers designed that. First of all, to protect the judges, to give them the independence they wanted, they gave them life tenure. So the Constitution says judges will serve during good behavior. And that means if they had, quote, bad behavior while on the bench, they could theoretically be impeached. It doesn't happen very often. And the understanding is this doesn't just mean, hey, it's decisions I disagree with, or, a relatively low level thing. It would have to be pretty, oftentimes something like corruption, where they're being bribed or something. So something particularly that might go to the core of the judicial office. But one imagines that maybe if someone was committing murders or something, they might be impeached too. That doesn't really qualify as good behavior, right? And that's also generally considered to be good behavior during office. So something that, turns out they found out that 10 years ago, this judge had committed a crime, that doesn't count either. It's really, well, as long as they're during good behavior while they're on the court. So practically speaking, this means that judges can, again, basically have life tenure. And historically, that obviously has meant different things. Early, particularly Supreme Court justices, it used to be a very difficult job because you do a lot of traveling up and down the new states. And that was obviously much more difficult at the time. And so you had people that either died even sometimes because of complications from that, because it was so difficult, and you'd get sick, or you couldn't get the proper treatment while on the road. But also you'd have people who turned down the job. John Jay, the first Supreme Court justice, left because he's like, I want to run for governor of New York. Nowadays couldn't imagine the Supreme Court Chief Justice doing that. Back then, the court wasn't as significant, and he had justices that were more likely to say, hey, I've got other stuff that might be interesting to do. So they didn't all necessarily stay life tenure. And then as we've gone through the years, there've been waves of people saying, okay, now some justices are staying too long. They're not retiring, and they're actually getting so old they can't really do their jobs. And now largely due to increase in judicial pensions, and federal judges actually, once they retire, can receive almost their full salary if they've been there for a certain number of years. So it was designed to say, you've done a good job, let's move on at a certain age, but yet they still constitutionally can't force them to do that. Now, on the front end, to get into the federal judiciary, you have to be nominated by the president, and then it says with the advice and consent of the Senate, they'll be appointed. So what happens is a president for the federal courts gets to choose the nominee, but then they have to be approved by the Senate. So the advice and consent of the Senate is generally taken to mean the Senate has to approve you, and that's by a majority vote, as they would approve anything. There are three types of federal judges, or three levels of federal judges. We hear all the time about the Supreme Court, but cases all start at the district court level. And I think maybe you guys have gone into some of these details. The district courts are spread throughout the country. Some of them, even a smaller state, you'll have the District of Rhode Island, just its own state. Larger states like California, you've got the Northern District of California, the Central District of California, and the Southern District of California. So the state might be divided into sections. And if you bring a lawsuit in any one of that, in the jurisdiction of that particular area, like if you had a lawsuit and the facts arose out of something that happened in Los Angeles, you're going to go to a court in the Southern District of California. And that's where the trial is going to happen in a federal case. And then at the end of that case, one party wins, one party loses. You can appeal that to the appellate courts. So the appeals courts are then divided into circuits. And there are 13 different circuits. Most of them are regional. So, there'll be a group of states that are all in the same area, like California, Oregon, Wisconsin, Alaska, Hawaii, and Arizona are all in the same circuit. Some of them are more topical. The DC court really just is in DC, which you'd think would be really small, but all the federal government is there. So they get a lot of cases suing the federal government. And then the federal circuit, which deals with patent law claims and court of federal claims issues. So that really just has to do with the topic area that they're real specialists in. Those appellate courts are also, again, nominated by the president, appointed and then confirmed by the Senate. And then, of course, the Supreme Court that hears all of those appeals that go up to them. They really don't hear all of them. They hear less than 1%, but because they have the option to only pick and choose which cases they get. The federal appellate courts hear all of them. And then because the Senate plays a role there, it's actually the politics become kind of interesting because the senators the senators from those states where the courts are have an outsized role in giving the president advice about who would be good. At the district court level in particular, there's something called the blue slip that you might hear about sometimes on the news. That's basically the option that senators have to blackball effectively and veto a nominee. If you have a nominee that the senator in that state is just like, oh, no way, not going to do this one, they will refuse to turn in their blue slip to the Senate. And the Senate agreement it's not a rule, it's not required, but they just kind of have come to the agreement that, what, we all will benefit if we have the ability in our own state to just block a nominee that we just find completely unacceptable. So the agreement is those nominees generally will not move forward. And that sometimes becomes interesting because you might have a state where the president's from one party and the senators are from another. So how do they come to an agreement? In those cases, often, it might be that there's 3 seats open in a certain state and the president's from party A and the senators from party B. You might end up saying, okay, the president, since he's the one who really nominates, he'll get 2 picks and the senators get 1 pick and everyone kind of has a veto on all 3 of them. But you kind of understand that, okay, we're going to probably not, the senator might not like these 2 guys as much and the president might not like this guy as much, but that they're just going to kind of compromise and split the difference. And that's normally how that process works out. Now, quickly to move on to the states, there are 50 states and there's basically almost 50 different ways to choose judges. I think they fall into a few major categories. First of all, the majority, well, not the majority, but I guess the almost majority, the plurality of states choose their judges by election. I think a lot of people might be surprised by that, but chances are you're in a state that might choose it by election. And that's 22 of the 50 states. It's interesting, early on, election was one of the most popular ways in the early colonies of choosing judges. And that was because they were reacting to the way judges were chosen in England. They felt like the king had way too much power. It turned into this just who's the political ally of the king gets to be the judge. And the people wanted to make sure that they had the ability to choose the judges. This particularly makes sense in state courts, because one of the things about federal judges is they are limited in the laws that they look at. They can just interpret the Constitution and the federal laws. They don't get to effectively make up law or create law, but there is something in the state courts called common law. And this has long been a situation in Anglo-American law, where there's certain areas where maybe there's not a law written on something, but they will draw then on a long history. And so there actually is a role in some of those states. A lot of people are concerned about federal judges being legislators from the bench, and that's not the role of a federal judge, but that sometimes can fit into the role of a state judge if there isn't state law on the topic. So it's kind of more reason why it might make sense to elect a judge in those cases, because then the judge is a little closer to, okay, representing what the people want for their laws. There's also been some interesting studies on the election of judges. People get frustrated by it sometimes because they're like, well, we don't want people, having to raise money and run for election. But there's also some important features where it allows for protection against intragovernmental corruption, because you'll see one of the other main ways that judges are selected is by some kind of appointment process, often involving the appointment of the governor. If you have the governor involved, or some other states, Virginia, where I live, it's an election by state legislature gets to elect them. In they're probably like 5 different states that have more of a pure appointment process by democratic process, but then there's 22 more that have some type of process where the governor has an appointment power. Sometimes it's limited because there's a judicial commission that picks who he can appoint from. Sometimes the governor has a broader power. But there are concerns that sometimes if you have that, you can have judges being beholden to the political party that helped them get there, that either appointed them or helped or elected them in the case of something like Virginia. So there's that pushing back on it as well. But then the advantage in some situation like that is the judges then don't have to worry about running for reelection. And it's a very challenging position to be in as a judge, to have to run on, you're limited in what you can say in terms of judicial ethics, et cetera. So that can be challenging, and you don't want to have anything where people are donating to your campaign that then would create in the appearance of impropriety, something where someone might have to recuse themselves. So that can become an issue as well. Some states have tried to deal with this by having what they call retention elections, in which everyone can just vote and say thumbs up or thumbs down. Here's incumbent Judge Smith. Do you want to keep her, or do you want to evict her? It's an interesting idea. It eliminates the need to run against an opponent. However, studies have shown that those type of elections are almost completely meaningless. Upwards of 95% of them, just everyone goes, well, sure, they seem fine to me, and they just reelect them. So I feel like those type of systems often give people a little bit of security, saying, well, if they're really horrible, we'll kick them out. But practically speaking, most people don't really pay enough close attention to what's going on in their state courts that there would be enough movement to remove a judge through that mechanism. So that's just a quick survey of where we are, what federal and state judges selection looks like, and I'm happy to entertain questions.
Wow, well, that was fantastic. That was a lot of information. Thank you. It's Janine, who's not on camera today, so sorry. All right, where to begin? All right. Okay. Geez, I have 4 things written down here, not exactly in orders. I'll start with, you were talking about on the Supreme Court level, that I believe you touched upon the fact that certain, well, anyway, the impression that I received when you were talking about Supreme Court is that in the past, both parties used to sort of be open and say Republicans would vote for a Democrat president's nominee, and a Democrat might actually vote for a Republican's nominee, but now that's just not happening. I thought it might be interesting if you would touch on that historically, because we have a lot of students that listen that only maybe understand today that Democrats are not going to vote for a Republican nominee, and Republicans are not going to vote for a Democrat nominee, though I think actually more Republicans do vote for Democrat, but it didn't used to be that way. Even about 8 years ago to 12 years ago. This just is a recent phenomenon. Maybe it's existed back in the 1800s. I don't know, but can you touch on that for a little bit?
Yeah. So it's actually kind of a mix. You're right. There in some ways there's been a contentious process, especially for the Supreme Court, for all of American history. One of George Washington's nominees, Chief Justice Rutledge, actually there was this huge campaign against him, and he ended up kind of stepping down. People were suggesting he wasn't mentally fit for the job. I don't even know. Just was like a lot of it had to do with his opposition to a piece of legislation at the time that he happened to speak out about in the middle of his confirmation process. So note to any federal judicial nominees, don't make commentary on political issues during the process, right? So there certainly have been contentious processes historically, but we also are absolutely living in an era that is probably the most contentious ever in American history. And now it stretches not just to the Supreme Court, but all the way down. So for example, district court judges used to be, until relatively recently, you didn't even have a vote that was recorded on them. The way they would do the vote is basically all in favor say aye, aye. It's called a voice vote in the Senate. So you don't even know at the end of the day who voted for them and who voted against them. It's just like everyone understands you're just going to move forward with them. And that was partly also a reflection of how much sway the senators held in the process. And so, hey, it's, as long as we're all of us as senators are the ones voting and we're all happy with the role that we play in the process, I'll vote for your judge, you vote for my judge, let's just move forward. And there's also the recognition that, the president has this, is the key mover in that constitutional system. So it's the idea of, all right, the president should get to pick who he or she wants on the court. Now, even for the Supreme Court, that has become much in the last 100 years more contentious, but I think particularly since the 1980s has become a very different process than it ever used to be. Before that process, it was really, with rare controversial exceptions, most presidents could expect that their nominees were going to be confirmed, particularly if they had a Senate that was of the same party, but even when they had a Senate in an opposing party. And as recently as the 90s, which just sounds pretty recent to me, maybe not to some of the audience, but was one of the most contentious processes. Most people will remember Justice Thomas's process. Actually, he was confirmed by a democratically controlled Senate, although he had been nominated by Republican George Bush. So even in a very controversial nomination, you had the opposing party confirming a nominee. If you look at the process, I think Robert Bork's nomination by President Reagan in 1987, I think it was probably the first time that it got this kind of modern era level of contentiousness. That was the first time there were TV ads run against him. There were hundreds of thousands of dollars spent on those ads. And that was just unheard of for anyone to be advertising and campaigning against a nominee. It's part of the reason Bork's nomination failed, because the Republicans in the White House weren't expecting anyone to oppose the nomination, let alone oppose it that vociferously. And the idea that he could be taken down by that kind of a political campaign was very surprising. But that's turned into really an accelerated process that has where all nominees, unfortunately, are a lot more controversial now. A lot of people point to the fact that there are more issues that get decided by the Supreme Court now than ever there used to be. When in the early days of the Republic, the limits of federal law, where it was much more limited. The Constitution wasn't read to cover as many things. The Supreme Court has read lots of things into the Constitution, including, like abortion is coming up this year. That's one of them. It has a broader notion of interstate commerce, and that's something that gets covered up, that has really opened up the number of things covered by federal law. The number of federal laws has expanded. So the court has just a whole lot more to say about the average American's life today than they did 50 years ago, 100 years ago, 200 years ago. So that's part of the reason it's contentious. And because so many controversial topics are now decided by the Supreme Court, it makes the whole confirmation process then controversial as a result.
Well, that you put that very most succinctly, and it makes a lot of sense. And I know that I think that the students that are listening think, okay, president appoints the Supreme Court justice nominee, and the Senate, confirms. But I don't know that anyone's really has been that aware, if they're younger, especially a student, that, well, the president also nominates a lot of judges for courts throughout the rest of the United States, these federal courts that are everywhere else. And I know when Mitch McConnell was the majority leader under President Trump, he kept talking about all the nominees that had actually been had been appointed and then confirmed under Mitch McConnell. They were talking about that. So I think that's another power of the president can affect not only just the Supreme Court, but all the other district courts as well. And I think that was pretty noteworthy. Okay, so talk about, and I want to turn it over to Tova, but the Marbury versus Madison scandal was interesting because it was John Adams and Thomas Jefferson won, and he was very worried about where Thomas Jefferson was going to take the country. So there were all those midnight appointments of judges throughout the country. You can talk about this a little bit. And then when Madison and Jefferson came in, there was this controversy, and they didn't want to honor a lot of those midnight appointments, and so that led to the lawsuit. Talk about that, because that was a scandal. And then supposedly the letter was lost by Madison that was confirming one of these appointments. It was a little bit shady, even back then.
And it's one more level shady even is that the person who was supposed to be Secretary of State, I believe, Secretary of State, I think it was, who was supposed to be delivering these was actually John Marshall, who was also Chief Justice of the United States Supreme Court. So going back to how the role of the justices of the court has really changed, no one would consider now, oh, well, you can be the Chief Justice and also you can be a member of the cabinet. Like, that's crazy. And then when he's involved in this case, nowadays, under our modern recusal rules, I think everyone would say, absolutely, John Marshall needed to recuse from that case. He was part of the facts of the case was about the actions that he had or had not taken. And so, but yet he sat in the case, and it's often considered to have been sort of a clever mechanism that he devised to decide the case, because he simultaneously established, I think we view that case as sort of establishing the principle of judicial review and saying it is the court's role to say what the law is. So the Supreme Court is the one that gets to decide how to interpret the Constitution and the federal law. And that's something that nowadays we kind of take for granted, but it wasn't as clear at the founding era, I think. And even now, I think there are people who would argue that, well, the court can just say what the law is in terms of deciding cases, and even the president needs to be bound by those decisions when they're referring to him. But each branch might have its own individual responsibility to interpret the Constitution. So say the Supreme Court says, yeah, we think you can do this in the Constitution. The president says, actually, that's not how I read it. I don't think I can. I'm not going to do that. That is within his authority to do it. It becomes a little dicier when the president says he can do something, the Supreme Court says he can't. That's when I think most presidents would say, okay, if the Supreme Court tells me directly I can't do it, I'm going to step back. But that's where that principle of judicial rule, of judicial review came about. But it was interesting because maybe some would speculate that in order not to get in trouble in that particular case or get people too riled up, Chief Justice John Marshall ultimately said, yeah, but in this case, actually, for some other procedural reasons, we can't carry that out. So he still left Jefferson's judges in place at the end. So he ended up grabbing a huge amount of authority for the Supreme Court, in part by abdicating authority over that specific role. So he let Jefferson have his judges, but now he's got this great authority sitting within the Supreme Court, which of course he was the head of.
Mm-hmm. He was very sly about it. But poor Marbury, is Marbury versus Madison, right? He didn't get an appointment under Adams. They took it away from him. He didn't actually get it. Yeah. All right. I do want to turn it over to Tova. I want to make sure everybody has enough time. So Tova, I have so many other questions I was going to ask, but I just can't because I have to share. Okay. So Tova, it's your turn.
Thank you. Yeah, this is fascinating. There's just so much in it. And I think it's cool that there's so many different methods for appointing a judge. But I wanted to ask, I remember reading an article about a judge being recalled. This was in regards to the Brock Turner sexual assault case, where the judge made a decision that a lot of people were angry with. And then there was this big campaign and the judge was actually recalled. So I was wondering, what is this process of recalling a judge? And is it similarly different in different states? And how does that work?
Yes. So that was a case coming out of California. And again, kind of like the retention elections, this is something that is a very unusual thing for someone to actually cause enough of a scandal or a crisis that they would actually get recalled. But that in that case, it did happen. And in that case, it was in California, and California provides that they can be recalled by the voters. And so that actually is what happened in that case. It's one of those, again, I think it's good to know that we have those checks. And I think there are other, different states have different systems. So, as I said, the federal system is life tenure, but I don't have the numbers in front of me, but I don't think most states actually have life tenure. So you can be recalled for things other than, say, a serious crime. And in that case, in California's case, you can be recalled by the electorate. So it's an interesting way to have a check. But again, I think, unfortunately, unless it's a major prominent case like that one happened to be, most judges, even if they make decisions that maybe everyone in the state would agree is the wrong decision, people don't realize it because it's not a decision in a prominent case.
Right, true. And then I'm curious about your personal opinion as somebody who has obviously a lot of experience with the judicial system. What do you think is, in your personal opinion, the best method of choosing a judge that you've seen in a state?
I kind of go back and forth. I think there are, and maybe you got this from some of my presentation, I do think there are a lot of advantages to elections in terms of, and there have been, some studies about, it's a little hard because it's hard. How do you rate judges and say, oh, which ones produce the best judges? But there have been some studies that have looked at, okay, which of the states where the judges get cited by other judges outside their jurisdiction the most, assuming that those are going to be the most influential and best opinions, or that get discussed most in the literature or something. And actually, elected judges fare very well on those metrics. But I also think there's a lot to be said for systems with a hybrid appointment system, kind of like the federal system. I mean, what the framers talked about is they said, well, you need to have the selection be put in just one person, so they can't pawn it off on someone else and just kind of pass the buck and blame someone else for a bad nominee. And you also want some check on that because you don't want just pure nepotism. So you don't want the president just like picking his best friends and his family members to be judges. And I think the federal system does that balance pretty well. I think in particular, one of the types of selection that concerns me, because it can lead to that just passing the buck thing, or it can lead to other groups that aren't even elected having a lot of say in the process for the members of a state, are what's called Missouri plan systems. And I forgot to mention this in my intro. That is probably one of the other, there's 12 states that have Missouri plans. And that's one of the other significant features. It was marketed originally as merit selection. And the idea is we want to take politics out of this. We want to just make it based on the merit of the judges. But as I had suggested, it's a little hard to say, well, how do you there's no SAT to take to say, well, who's a better judge than this person? You don't have a report card unless you want to go back to their law school grades, which hopefully by the time they're going to be a judge are well behind them, right? So what this process does is it says there's a commission, and in this commission, it gets to pick often 3 nominees that get handed the governor, and the governor then just pick whichever one he or she likes off of that list. The challenge is, all of these systems are going to end up being political, right? And so this one, because there's this commission that most people in the state doesn't even know exists, the ability of getting people on that commission and who those people are becomes political, but I think a worse kind of political, a behind the scenes political. And that's kind of why I like the election process, because it's going to turn political in any sense, but at least that politics is out where everyone can see it, and you have a vote in it and you have a voice in it. Whereas in the case of putting people on judicial commissions, oftentimes it's largely controlled by the state bar. So it's not even something that the majority of the members of the state even have access to. The lawyers have a very heavy hand in being able to choose it, even though these are the judges that serve the people of the whole state. And it allows the governor to be able to say, well, I'm just gonna, if the judge doesn't turn out good, well, yeah, all I can do, it was just what the commission gave me. And so they kind of do a lot of passing off the responsibility. I think having some accountability more directly to someone who, either to the people directly or to someone who is themselves directly accountable to people, like the governor or like the the state legislature or some combination of that with the federal system. I feel like that puts it back more in a more representative and accountable system.
Wow, that's fascinating. Thank you. And then are there any specific qualifications you need to become a judge? Like, for example, or a Supreme Court justice, you know, to be president, you have to be 35 and born in America. Is there anything similar with judges, or is it much more open, and how is that determined?
Amazingly, at the federal level, really, no, you don't even technically have to be a lawyer. There's no, it's really, the limit on that is effectively the fact that there's a political method of selection. So, you know, in theory, a president could appoint someone who's not even a lawyer to the Supreme Court. You know, it's a good big question whether the Senate is going to actually confirm someone who doesn't have legal training. And then if the American people would be like, whoa, 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 what are you doing putting someone who hasn't even graduated law school onto the Supreme Court? So it's in some sense, if you have a properly functioning political check on the front end, then maybe you don't need some of those limitations on the back end, because if they start appointing people who either are, you know, not qualified or have other serious failings, you'd hope that then that would be, they'd get pushed back at the ballot box. And I think that's thus far how the system has worked. There is no age limitation. I believe the youngest appointee to the Supreme Court, it was 32, and who was actually a very illustrious judge, Joseph Story. Nowadays, no one would get nominated in their 30s. However, we do now frequently have nominees in their 40s. Justice Thomas, who I clerked for, was nominated when he was 43, which sounds younger and younger every year, but he still hadn't even paid off his law school debt when he was appointed to the Supreme Court. So nowadays, I feel like a lot of people feel the sweet spot is more, you know, probably in your upper 40s, early 50s. That's where the last several nominees have come, because you have to have this balance again of someone who has enough experience and you know, years that you can look at what they're, because if you're the president, how do you decide who to pick, right? You have, if you pick a 30-year-old, you don't really know what he or she is going to be like 50 years from now, because they're going to be sitting till they're maybe 80 some years old. This is what we've seen in recent years. And so the president has to balance that, you know, when do I have enough information about this person and they have enough experience and qualifications with, I also want to appoint someone who's going to have a long-term influence, because it is one of the most influential decisions a president makes. These people, you know, the president is long gone. Their executive orders get canceled day one of the next administration. Any laws they passed might get overturned by a subsequent Congress. They might get reinterpreted by the court. They might get struck down as unconstitutional. But the Supreme Court justices that they put on the court often will serve 20, 30, even getting on to 40 years. Justice Thomas just recognized his 30 years on the court, and he's only 73. So he could easily serve for 10 more years. It's really a huge impact. And they're going to be, these are the justices who are going to be interpreting the Constitution and the laws for the whole next generation.
Well, thank you. And then my last question is, what are the important, like, personal attributes or qualities in a judge? And are those different at the highest Supreme Court level versus a more local level?
Well, I think it's going to be the same attributes that are important in a judge all the way up. Obviously, they get a different level of scrutiny for the Supreme Court than they often do at the lower levels. And there are some different skill sets that are going to be important for judges who are doing trials and that kind of work at a district court or a trial court level versus an appellate judge. So obviously, all judges are going to have to be, you know the law inside and out, and be very good also at probably learning new areas of the law, because you can study all you want in law school and for the bar exam or something, you're never going to learn every single area of law. And you're going to often find cases that have new and different factual scenarios. And you might find yourself having to kind of do a lot of digging to find out what the law is in a certain area. So they're going to need to be able to get up to speed quickly on new areas of law as well. So you need someone who has just a lot of understanding of the legal process. I think you also want someone who has a very clear understanding of their judicial role and philosophy. You don't want a judge who thinks they're just going to go in here and, you know, be a crusader for what they think is right, because as a judge, you take an oath to, at least as a federal judge, you take an oath to uphold the Constitution and laws of the United States. You don't take an oath to, I'm going to do whatever I think is right in the case, because that nullifies our constitutional process that says the American people are the ones who make the laws. So you have to have a judge who has the ability and the humility to be able to step back and say, okay, I might think this law is completely wrongheaded. I might have voted against it every day of the week and twice on Sunday, or I might think this law is really badly written, it's sloppily written. Anyone who talks to you, who has seen how the laws are made, this is why it's compared to making sausage. It's not pretty. So oftentimes there are mistakes. There are things that weren't put together well or weren't really thought through. It might be that the law is really out of date that they're applying. Like, oh my gosh, seriously, Congress hasn't updated this since 1953. Like, we need to get on board here. But it's not the judge's role to change those. So you have to, as a judge, be able to say, hey guys, I am sticking to my role. And the good thing is, if the judges stick to their role, that then puts more pressure on Congress to do their job. They always would rather not have to do their job. Then they don't have to answer to the voters for what their vote was in a certain case. They'd much rather, let's let the judges take care of it. And then I'll either complain that I disagree with them, or I'll applaud them and say, hey, great job. But that's not how our system is set up. We need to actually have the accountability at Congress to make our laws, because those are our elected representatives. The judges weren't elected at the federal level by us to make our laws. I think also a strong dose of courage, and that sometimes means courage to stand up and say, hey, we all agree this law is wrong and I have to apply it anyway, and you guys fix it because that's not my job. It means the courage to stand up to political pressure, because you're going to get people who, are writing op-eds about you or want you to decide a case a different way. If you're a trial judge doing a lot of criminal cases, it might be the courage to face a lot of bad guys who now have your name on their list. And this is why we have a U.S. Marshal Service at the federal level. And this is why judges have to have a lot of protection at the state court level, because you can run into a lot of bad people who then, have you that is someone that they want to get back at if and when they get out of prison. And that can be dangerous for judges and their families as well. So I think, those are probably my chief qualifications. And I would hope that judges would have those, from the trial court judge who's going to have to manage the intricacies of a trial. They have to make a lot of decisions quickly and on the fly. That's probably a really important role there, because they're actually carrying all this out and having to make rulings in real time. Appellate court judges, I think in particular, are going to have to specialize, and that would include the Supreme Court and the state Supreme Courts as well. They specialize in almost this, it's like being a law professor and an academic. So they're looking at a case and really digging into the details after all the facts have been figured out at the lower court level.
Wonderful. Okay, Essie, am I muted? I'm not muted. This is just terrifically informative. Jewel Gilbert, you're on. It's your turn.
Hello. Learning so much. Can you hear me fine?
I can hear you.
All right. I was wondering, so we heard about so many different courts and levels. How does a judge move throughout this? How does a judge normally get selected? And then do judges have an eye to want to move up through these courts? Does a judge end up sticking in a state court or moving from state to federal? And then the judges in state courts want to go to federal?
Yeah, that is a great question. That's very insightful. What often happens, certainly within each system, you often see some movement. So, someone might start out in a family court or in a probate court, a lower level small claims court, and then work their way up within the state courts. There are some people who kind of are lifers in a certain area, and then people who will kind of jump from being a law professor and then become a state appellate judge or a state Supreme Court judge. I think it's frequently, particularly if you've got a gubernatorial selection or something, you might see them being able to tap then people who were someone who might have worked as an attorney general of the state before, or who had, again, been a prominent law professor. I'm just thinking of some examples offhand in my mind of different people or who were well-known local lawyers, and then bring those people into the process. When you have you also might have a process where they start moving up. Going from in the federal system, you often, and we've seen this in this administration, we saw it in the last administration, you'll often see the federal district judges getting appointed to appellate positions, and almost universally, the Supreme Court nominees are going to be taken from the federal appellate bench. It was interesting to see, and President Trump, who was the first president that I know of to put out his official short list. It wasn't super short. It ended up being like 36 potential judges. But his list also included a lot of state court judges. And I think a lot of people saw that as significant because, for better or for worse, federal courts are often seen as more prestigious among lawyers than a state court judge. It's in one sense, it's logical because they've got life tenure and they're deciding these federal cases, but it's sort of too bad because I think it means that people who are highly qualified sometimes don't try to go within the state court system. And actually 90% of cases that are filed in the state court. So it's really important. It's a lot of important law gets happen, a lot of important decisions get made. But I think we're seeing an increase in the prestige of state Supreme Court justices. And I think that's good because it also that's what drives top-notch talent to want to be a state Supreme Court justice. Because then you're like, oh, people are going to look at me. This is a good job to have. I want to have it. Because none of these judge positions actually, at the end of the day, pay anywhere near as much as like being as someone of a lawyer of that quality normally could make in the private practice. So you want these jobs to be sufficiently, something they're going to be a mark of pride and want to do, not merely as an act of service, but hopefully they have a good sense of public service as well. But I think that helps draw good talent.
As you said about how the judges are selected, is it similar to what you answered one of Tova's questions, that they'll look for possibly if other judges are citing them, and then mixed with whether they have ruled in past cases, how that political agent sees fit?
Yeah, so different presidents are looking, and different governors similarly are looking for different things in judges. And so you're going to see different things emphasized by different people. President Trump was very outspoken about wanting judges who had a specific judicial philosophy, originalism and textualism. That means interpreting the law as it's written according to the words that are written and the original meaning of the laws. And so a lot of the focus of the vetting during that administration was, let's look at what their judicial philosophy is, and let's try to find examples in their writing or in their if they were a judge previously of what their judicial philosophy was. President Biden, some of the things he's focused on is diversity in several areas, both in terms of he's appointed almost all of his nominees have been either female or minorities. He's also trying to appoint more people who are coming from the defense side of the bench. I think that there have been historically a lot of prosecutors who've been appointed to the federal bench, and he's wanting to appoint more former defense attorneys. Part of the sort of implicit logic, and President Obama talked about this more explicitly. He said basically his position was about 95% of the cases are decided based on the law, and about 5% probably end up being decided based on what he called empathy. And Biden hasn't articulated the same empathy standard, but he was obviously in the Obama administration. And I wonder if that's part of the thing that's driving his leaning toward having more defense attorneys, the idea that they're going to sympathize more with the defendant than a prosecution. That worries me a little bit. I would hope that that our judges are going to be neutral and not sympathize. I would hope that you don't have ones that are sympathizing with, I'm going to always rule with the prosecution, or I'm going to always rule with the defendants, or I'm going to lean that way, even have a thumb on the scale. I would rather see judges that are just neutral, and I hope that his judges are that way. We'll find out. Currently,
we have different, like you just said, originalism, textualism, and then I'm not sure exactly what the other, what we would say more towards the other side is. I know they consider the Constitution a living document, but I don't know what they call their idea of judging. Early on, was there a clear part, like almost a polarization in that along those same lines going back towards the beginning of the country? Can we map that same thing onto the beginning of the country as well?
It's not going to be the same. So the debates that we have now, I feel like are largely about how do you interpret the Constitution or the text? So I would say it's hard to, I agree, it's actually hard to know what the right contrast to originalism and textualism is. I would say living constitutionalism is one argument, and Justice Breyer has been very outspoken for this idea that the Constitution evolves and changes, and that justices have to kind of take the words in a much broader sense than maybe they were understood at the time, and kind of bring them up to date in different ways. And so the idea is should the Constitution be a document that is set and only be changed by amendment? Or is the Constitution something that can effectively be amended and morphed over time by judges and by judicial interpretation sort of developing? I think in the early Republic, it's a little hard to say, because when you talk about what is the original understanding of what these terms were, the early justices were literally the same people who were like there in the original time. And going even into the 19th century, you've got a lot of the people who were there for the revolution. And so you didn't have the same, there were definitely divisions at the time over what the Constitution meant, but I guess they might have all qualified as versions of the original meaning, because it might be the Federalist and the Anti-Federalist, which it sounds like you guys have
And to me,
discussed
I
already.
wonder, and luckily we just did we did a long study on the Federalist Papers, as you might know,
Mhm.
here at Constituting America. And when I look at the legal system now and the judicial system, it's very hard for me to understand how a judge not claiming to be an originalist or textualist, or adhering to a natural law theory of law, can take an oath to the Constitution when that's so explicitly it relies on it. So it's almost like it's hard to reconcile the different way that the judges rule when an entire party basically doesn't believe in the bedrock of what the Constitution was laid on, which was kind of a natural law theory of trying to come to some objective truth and protecting of objective rights, and then judges trying to rule based on that. So within the originalist camp, it's like you could have fiery debates about what it meant, but then if you step outside of that from the outside, it must be very hard to communicate from within an originalist view to outside of an originalist view, because it's almost like apples and oranges.
Yeah, and I think to one extent it's interesting, the originalism and textualism, because of some of the concerns that you talked about, actually has been gaining a lot of traction in legal academy and within the law generally. It used to be kind of scoffed at in maybe the early 80s, and now I think it's really, even Justice Kagan, who would not consider herself an originalist, but during her confirmation hearing said, we're all originalists now. And I think she's alluding to the idea that everyone coming before the court now recognizes they at least have to have some foothold in an understanding that this is what the text says. It used to be, 30 years ago maybe, that you could come up and they would argue a case about a provision of a statute and never actually quote the statute, and which nowadays sounds like, wow, how are you fulfilling your oath to uphold the law if you're not actually even reading what the law is? Why is our legislature bother making this sausage if no one's going to even look at what they wrote and what they actually voted on and what the president signed? So I think we've come to a point where both sides, to a certain extent, recognize the necessity to look at the text and to make an argument from there. I just think there's certain approaches and the challenges, and this is something Justice Scalia said, that once you open the door to having to kind of evolving the Constitution into something else, then it's very hard to separate just your own personal politics or your own personal views on things from where you're evolving it. So are you really interpreting the Constitution anymore, or are you just kind of reading your own desires into it? And what Scalia said is, if we're doing that, then it's no surprise that we're going to be treated like politicians in our confirmation processes, because effectively you are voting for what I believe and what I think in my heart of hearts, not just my effectively, my legal ability and my ability to read a statute and interpret it.
Thank you very much.
That's where we are. Thanks.
Thank you for your answers. This was awesome. We got some audience questions now.
Yeah, thank you, Jewel. And thank you so much, Carrie. This has been so enlightening. And we have so many great audience questions. John Goff asks about the relationship between judges and juries. He says, is it true that under common law and the founder's intention, the state courts are supposed to function in a way where the judge serves more in an advisory role to the jury as far as what the law is, but that the jury can make an independent decision from the judge if the jurors find something as being unconstitutional in their unanimous opinion? And then he goes on to say, to my understanding, this has changed, and now the judge tells the jury what is constitutional and what is not, thereby taking away their independent standing. Is this true? And if so, where do you stand on jury nullification? Is it practical and realistic?
Wow, you have an incredibly informed audience. I'm just floored. So, juries still do have a really significant role, because they are ultimately in cases where there is a jury, they are the finders of fact. So they get to decide, when witnesses come up, they're the ones who decide, yeah, I think you're telling the truth and I think you're lying, or here's two experts and yeah, we think this one is, we're going with that. And even if the judge disagrees, unless they come to the conclusion that basically there is no possible legal grounds that you could believe that this guy is, credible or this guy is not credible. And that would be a pretty extreme case. Then the jury's decision has to stand. So the jury still has a very significant role in that case. And the judge's role really is they in those cases will decide which evidence to let in and which evidence to take out, because that's a legal question. That's not a question of, it has to do with whether it's relevant and or whether it's prejudicial, and kind of balancing those two factors. And that has a lot that can direct the way the jury goes, because if the jury doesn't see evidence, they're never going to be able to react to it. There's a big Supreme Court case about the Boston Marathon bomber that's actually has to do with one of these jury evidence questions of they wanted to introduce more evidence about this guy's brother who had been accused but not convicted of several other crimes. And it didn't end up getting before the jury. And maybe the jury would have done something different if they had seen that. Maybe they would have thought he didn't have as much to do with this bombing and it was his brother leading the way. In terms of the nullification process, I think today it's basically accepted that the judge is kind of the final arbiter on the legal standards. And even the trial judge isn't really the final arbiter, because the trial judge's legal conclusions then can get appealed up to the appellate court, and then are going to get appealed up to the Supreme Court. So the jury is really just been reduced to a finder of fact, and their factual conclusions are going to be, again, unless they're just completely they're just legally impossible that they could come to that conclusion. They're going to be respected, and so that ends up having a major effect in the later cases. But the legal questions are going to be then decided by the judges. I'm not a historian and able to comment on whether that was really how broadly that was the case in the early Republic, but it certainly has not been the case today. And I think now that's something that's reserved for the judges. And honestly, I think that's probably the best solution on that process, simply because I think the likelihood that the jury's if you're talking about like a legal conclusion of whether something's constitutional, I think it's unlikely. It's hard enough to get a judge to set aside his or her emotions and gut feelings about, the policy of an issue, or this is just such a horrible guy that's the defendant in front of me or not. I think it's a lot to ask of a jury to be able to make those complicated legal conclusions and then set aside maybe their other political or policy or ideological feelings about the direction the case should go.
Well, thank you. And then Brian Ernst writes, why is a single judge at the federal level allowed to control staunch certain actions of the government based solely on his or her decision alone? Considering the founding fathers spent a lot of time and brain power to negate one person having such power, this seems not only to be unconstitutional, but anti-constitutional. Do you have any comment on that?
Yeah, so I think this is something that has become a concern before the court, particularly in the last 5 years or so, because there's been an increase in what's called universal injunctions, where you might have a judge in a specific case have an injunction against, like, say, the federal government from applying a law anywhere in the country. And that's really not historically how the cases have worked. The Constitution does say that judges, that the judicial powers over cases and controversies. And the Supreme Court has, stated within the last few months, even in the Texas case, that they don't enjoin laws. They're not here to decide even the constitutionality of a law broadly. They decide cases. So it has to do with this particular plaintiff and this particular defendant. And maybe the court will say this particular plaintiff cannot continue doing what they're doing, or the defendant can't continue doing what they're doing, but it's not their role to decide, to say once and for all, we're going to enjoin this law. Now, it could be in a case, you can imagine a case where it's like the Texas Supreme Court says, actually, we think this violates the federal Constitution. We're going to say the state can't keep doing that law. That makes sense, because if the state government is the one that's on the other side, you could block them as one of the parties to the case from applying that law elsewhere. But I do think there's been an abuse of the system where judges have reached out and tried to make much broader rulings than they actually have the authority to do.
Well, thank you. And I think we could take this another hour easily, but we're a little bit over. It's 3:01. And Janine, would you like any closing comments that you want to make?
Well, I just want to say thank you, Carrie. You were terrific. Just simply awesome. We've learned a tremendous amount on the show today, and I thank you so very, very, very much. I'm impressed. I'm your fan. I'm following you. I'm buying your books.
I'm so impressed by your audience and your student questions. This is a great discussion, and frankly, it's some better questions than I often get from law students or lawyers. So well done.
We do. We have a great group of students here, and Kathy and I are proud to be a part of this and founding and co-presidenting, is that a word? This foundation. So thank you, Tova. You want to sign off and say your salutations?
Yeah, thanks everyone for being here. This was fascinating as always. Have a great week.
Jewel.
See everybody. Thank you. Back to the poll station.
He's working the polls. Proud of you, Jewel. That's amazing. There you are. Look at that. Okay. Thank you, Carrie. Appreciate it so much.
And we want to invite everybody back next Tuesday at 2:00 for our episode on federal courts, appeals courts, and district courts. So come back next week at 2 p.m. and our guest is going to be Horace Cooper. So thank you so much.
And Carrie, your books are on Amazon, yes? Very good. Okay. Thanks so much. Take care. Thank you, everybody.
Bye.
Bye.